In a panel discussion hosted by the National Constitution Center, 3 originalist scholars were invited to discuss originalism and its history. At the end of the video, the host, Jeffrey Rosen, president and CEO of the National Constitution Center, asked each participant to give their best defense of originalism. Each provided a different argument, and I intend on creating a short video discussing each of those arguments. Here I'll discuss the defense provided by Anastasia Boden of the Cato Institute. To introduce the topic, originalism is the thesis that judges should interpret the Constitution of the United States by attempting to discover the original public meaning of its words and phrases. To determine if a punishment is cruel and unusual, we have to ask what people living in 1790 would have thought was cruel and unusual, and so forth. It provides 2 arguments for originalism, one that she says is convincing to most people, and a second which is her own most important reason to be an originalist. I'll take these arguments in order, looking first at the argument that Boden says is the one that would appeal to most people. She says, quote, "In order for the Constitution to be a document that establishes rule of law that actually limits government actors, it can't mean whatever we want it to mean at any given moment. It has to have a fixed meaning that constrains government action. In that way, it bolsters rule of law, it bolsters limited government, and it bolsters separation of power." End quote. Effectively, this argument states that there are 2 options. You are either an originalist, or you believe that the Constitution can mean whatever you want it to mean at any given moment. It's absurd to hold that the Constitution can mean whatever you want it to mean at any given moment, therefore you must accept originalism. Among philosophers, this type of argument is known as a false dichotomy. It incorrectly claims that there are only these 2 options, and since one of the options must be rejected, we have to go with the other option. Since the Constitution can mean whatever we want it to mean at any given moment must be rejected, we have to go with the option of originalism. But these are not the only 2 options. In fact, you'd be hard-pressed to find anybody who says that the Constitution means whatever we want it to mean at any given moment. This leads to the second problem with this argument, which is actually quite serious. This argument represents a type of rhetoric used to try to deceptively manipulate others into accepting a conclusion rather than convincing them with reasoned argument. The telltale sign of this is the utter absurdity of one of the options, the option to be rejected. In contrast, an academically honest argument is one that can be reasonably asserted, even if it turns out to be an error. In philosophy, this is known as applying a principle of charity. Academically dishonest and manipulative rhetoric warrants a different type of response. Its use represents a moral failing on the part of the person who uses it. In fact, people who reject originalism would agree with Boden's initial premise. In order for the Constitution to be a document that establishes rule of law that actually limits government actors, it can't mean whatever we want it to mean at any given moment. What the actual critic denies is that fixing the meaning according to the original public meaning of the authors is the only or the best or even a good way to accomplish this goal. I'm attracted to a view that, instead of limiting terms like due process, unreasonable searches and seizures, and cruel and unusual punishments according to the original public meaning, that we use the most defensible understanding of these terms. For example, the command to be nice is not a command to do what the speaker thinks is nice, but a command to do what is actually nice. By analogy, a command not to inflict cruel and unusual punishments, or to provide due process, is not a command to refrain from punishments that the speaker takes to be cruel and unusual, or to count as due process what the speaker thinks people are due. It's a prohibition on punishments that are actually cruel and unusual, and to use those procedures that people are actually due. Now, Boden might have objections to that view. That's fine. But it misses the point. It's quite legitimate to present an opposing view honestly and to show that there are flaws with that view. What's worthy of condemnation is creating an absurd and dishonest misrepresentation of the opposing view and telling readers that they must choose between that straw man and originalism. So what about Boden's second argument? Here she says the following, quote, "Originalism locks in an initially legitimate lawmaking scheme, a system of government that is inherently legitimate because it limits government power. It contains strong protections for individual liberty, including procedural protections like due process and separation of powers. And because it is locking in something that is initially legitimate and secures all of our rights, I think it's a legitimate form of interpretation." End quote. My first objection here is that the position Boden is defending with this argument isn't originalism. Originalism says to interpret and apply the Constitution according to its original public meaning. It says nothing about locking in protections for individual liberty or separation of powers. It was perfectly legitimate, even obligatory, according to originalism, to interpret the Constitution in a way that condemned 4 million people to bondage for over 80 years. Those provisions did not protect individual liberties, and it was perfectly legitimate for nearly 150 years for the Constitution to deny women participation in government. One can argue that this is not due process. Imagine the Supreme Court in the 1830s ruling that the Bill of Rights were applicable to individuals regardless of skin color or gender. Originalists would have been up in arms about that decision. This ruling, which would have protected individual liberties and expanded due process, would have been utterly condemned as an illegitimate act of judicial activism. I'm going to suggest a way of reforming Boden's argument. The reformed argument states that either we apply originalism to interpreting the Constitution, or we risk a situation in which judges make decisions like, just for example, outlawing the Bible as hate speech. To prevent these types of violations, we promote originalism as the true and correct way to interpret the Constitution. We can find evidence that Boden might endorse this reformed interpretation. She said, quote, "I don't think that democracy is the guiding principle of our Constitution. Individual liberty is, and having been a civil rights attorney, I don't look favorably upon deference because I want to just engage with the Constitution and to strike down laws. The whole point of the judiciary is to be counter-majoritarian," end quote. I think we see here a reluctance to have judges bowing down to the will of the legislature or the majority, but to appeal primarily to a third thing which has the ability to defend individual liberty. And while the Constitution may have been a poor protector of individual liberty in the past, it's much improved in that regard. If this is the move that Boden would make, then this is a move that would be known in philosophical circles as a Platonic noble lie. Plato argued that the public at large is incapable of understanding the complexities of important political institutions and practices. Therefore, it's up to the philosopher king to determine what is best for society and then explain it to the people by the use of convenient and effective fictions. In this case, the convenient and effective fiction would be the fiction that we must use the original public meaning of the text and nothing else. Instead of defending these individual rights and due process on their merits, she intends to defend them on the grounds that the original authors of the Constitution told us to do it this way. There is a bit of paternalism in this approach. Think of a parent who thinks that a child is incapable of understanding the reasons behind some rule or practice. She tells the child to do what you're told and because I said so. Only in this case, it's do what you're told because the original authors of the Constitution said so. And again, the alternative is not that the Constitution can mean whatever we want it to mean at any given moment. The alternative is interpreting phrases such as unreasonable searches and seizures and cruel and unusual punishments in terms of what we can defend as reasonable and not according to what was believed 250 years ago. Perhaps Boden's noble lie defense of originalism is the best option. I haven't provided any objections against it. However, while it's possible for a noble lie to be useful, it's still a lie. We're telling people that the original public meaning is what's important, when in fact it's the individual rights and due process that are actually important. And when originalism becomes destructive of these ends, then it has to be abandoned. So in the end, Anastasia Boden gave us 3 arguments for originalism. The first was the academically dishonest and manipulatively false dichotomy between originalism and the Constitution means what we want it to mean at any given moment. The second was the claim that originalism defends individual liberty, limited government, and separation of powers, which is only contingently true. While the third argument admits that originalism only contingently defends individual liberty and due process, it happens to do so at the moment. And so we are to promote originalism in the hopes that people will accept it as a way to realize certain political ends when they can't be expected to understand and support those same ends on their merits. I'll have a third video in this set where I will look at the defense of originalism offered by the third speaker in this panel discussion.